Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye.
Okay. So Kansas Star says, I reviewed my employment records and I saw I missed over 1,000 hours of work my last 2 years of employment, FMLA sick leave and sick leave pool hours. How should I explain that kind of attendance issue to the judge? And if it clearly shows your functional limitations. Well, I mean, I think that you have to draw a connection between your missed work and your medical issues. Just missing work doesn't mean you're disabled, but obviously if that's consistent with diagnosis and treatment, again, this is something where that evidence at this time would be something to submit, and you'd want your lawyer to draw that conclusion in a brief and also in your testimony. So, yeah, it sort of speaks for itself, but you want to make sure you explain that the reason you missed all this time was because you were going to the doctor or you were having really hard problems getting out of bed or whatever the case may be. And, the other question is, how did you manage to keep your job with all those absences? But I think you just have to have some way to make that connection.
She does mention FMLA, so that might have been intermittent. Maybe she had, which would by definition be assuming it was a sick FMLA and not a child or family member.
Right. That's good. Yeah, you can't, if you went on FMLA because your mom was sick or you had a sick kid, God forbid, that doesn't mean you're disabled. And people sometimes say, well, I had to stay home to take care of my child. Well, it doesn't mean you're disabled. But yeah, assuming it's for you, for medical issues you've got, if you can identify those medical issues and somehow link them to the time you missed. And again, this is where a third-party statement can come in handy. A coworker who can talk about what he or she observed about you and the problems you were having. But I think that is a very strong bit of evidence because it shows that you were missing work. And again, vocational witnesses, which most judges will have in hearings, will testify that between 10 and 15% off task in the course of a day or ongoing is a problem and would preclude competitive work, as would missing a day of work a month. And some VEs will say 10% off task, others 15%. But this amount of time, 1,000 hours, that's a lot.
That's like a quarter of a year. That's a lot.
I would probably narrow it because presumably your onset date is after you stop working. I would really look at the last 3 or 4 months in particular. You can have the other stuff there, but say the last 3 or 4 months, either it got worse or it stayed the same. But yeah, this is what I was dealing with. But I think you will need to explain how you kept the job. Well, maybe it was your cousin was the supervisor, or, you're working at home or something like that. Because that obviously the VE is going to say that's not consistent with competitive employment, yet you kept your job. So how did you do that? And like I said, sometimes it's because it's a friend or a relative or somebody who was the boss.
Or the FMLA, where they couldn't.
Right. Okay. All right. So again, I think this.
Now,
go ahead.
I was just going to say, accommodations can be damaging, can hurt a case.
How so?
I believe, because it's my understanding when they're looking at your past relevant work. So if it's in your relevant 5 years, and you had an accommodation, that's included as part of your past relevant work duties. Like they don't look at it for future jobs, but for the past relevant work jobs. So it's like if they find you could do that job with that accommodation, then you could do that job. And even if even if the accommodation no longer is offered or exists, because it's crushing, really. I mean, I always tell people, don't even go into your accommodations, because if it's part of your past relevant work, it's one of the Social Security rulings.
Okay.
As a matter of fact, yeah, it's like, so sometimes people, sometimes people will say, well, I had a lot of accommodations. My coworker used to help me instead of me carrying the water the whole way, they would, start helping me or whatever. And I'm like, was that official or was that just them being kind? Well, that's just them being kind. But if I'd asked for it, I'm like, you don't want to ask. I'm like, let's not go there. If it wasn't an official accommodation, you can talk about how you had to get a lot of help and weren't doing the job fully yourself. But the second you might broach into accommodation, if that's going to be a job in your past relevant work, now you have to prove you can't do it with accommodation. So it just makes it harder to prove you can't do it.
I see what you're saying. So it's almost the same. And the other side of it would be if you had a job that, you actually performed. Let's say the job is like I had a client who was a firefighter and is classified as medium. And he talked about he had to lift 100 pounds. So it was performed at heavy. So they look at your past relevant work, they're going to consider it as a heavy job, but that's what you did. What you're saying is on the other side of it, if you, let's say the job normally required you to lift 20 pounds, but you only had to do 10 because you had an accommodation, the way you performed that past job was 10 pounds. And so you got to prove you couldn't do it that way, I think is what you're getting.
Yeah. It's an annoying little factor there on that one.
Got it. All right. So
hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey all, I just wanted to re-review because someone had questioned this with regard to a different issue. And I always like to double check my research, particularly if it's been a while. Things can change on a dime, when it comes to the law. But also, what if I made a mistake? I would not be too humble, or I would not be so unhumble as to not confess. So I don't think I did, but let's take a look at it. The question concerned accommodated work. And if your prior work that is in that prior work period relevancy that the SSA will be looking at when it determines if you are disabled or not. Step 4, if that prior work was with reasonable accommodations provided by your employer, what happens? Does that count if you could still do that job when it's accommodated, but maybe you couldn't do it if it wasn't accommodated? Okay, so what we're going to look at is, this is one of the POMs, DI, so capital D, capital I, 25005.020 past relevant work as the claimant performed it. Okay, because as you know, you have to prove that you can't do past relevant work as you performed it and as is otherwise regularly performed for that job in the rest of the economy. All right, I'm going to scooch on down. There's many, if you're following along, don't know if you are, down to section F. I think it was F. Yes, F. This section says evaluating work with accommodations provided by the employer. And I'm just going to read a little bit and then kind of jump in. So here the SSA is telling its staffers that make these determinations what they should be doing. It says evaluate the ability to do past relevant work with accommodations provided by the claimant's employer as follows. First bullet point, if a previous employer offered accommodations that allowed the claimant to perform the past relevant work with their impairment, and the claimant retains the ability to do the past relevant work with the accommodation in place, you find that the claimant is able to do past relevant work as they performed it, even if, and I know I talked about this before someplace, guys, even if the accommodations might not be available in other workplaces, or if work ceased because the employer removed the accommodations. That is a really tough nugget. It's almost like, I don't know, almost like a deterrent for someone who needs a reasonable accommodation and could work with one, but perhaps has a progressive disorder that's going to slowly get worse. But that's always a hard line to define when you have a claim. Might make them a little concerned because that accommodated job might be to put a fork in their ability to have a claim. So I don't really like that rule. I'll have to think it out more and see if there's, more valid reason for it that I'm not seeing, but I don't like it. But there you have it, guys. For past relevant work purposes, reasonable accommodations will be something you have to overcome when proving you can't do that job. You have to prove you can't do it if those accommodations are still there. I will just read the rest of the section. Be alert to the possibility that such work may not be SGA due to a special employment situation, such as, and we just talked about this recently too, unsuccessful work attempt or impairment related work expense. Those are all kind of discussed in a variety of other videos over the course of time. And I believe they each, certainly IRWI's impairment related work expenses has their own playlist, I think. Not sure about unsuccessful work attempt. I don't know, maybe if we have a few videos lined up, maybe we will make a section for that. But then they go on to say, or that because of an extensive subsidy, the claimant's earnings are not SGA. So that just drives the home. And I think when I was the viewer who had commented about firmly believing that if it was accommodated work, it doesn't count for SGA. Not true, as we just saw. However, it is accommodated isn't the issue. If it was a subsidized work, which is also kind of in the realm of sheltered work, it's when you're actually getting paid more than what the value of your work is, and it's because they're being kind. There are some companies that make a practice of doing that. They might get tax breaks. I'm not sure, but it's called subsidized work. You could have a person who doesn't get much done. They might be very, very, very limited in what they can do at all. But perhaps on the job, they could be a great goodwill ambassador. They smile and say hi to everybody. We've all seen people limited in this fashion out and about occasionally in certain jobs that you can't imagine would otherwise actually pay their way, but they're getting at least minimum wage. Maybe they're there for 8 hours, and the demands on them are extremely limited. Not really something you'd find in vast numbers in the competitive work environment. That could be a subsidized job. It is often for very mentally or cognitively limited folks. It's awesome, I think. It's so good for them. So I really appreciate the employers that jump on board, and good for them if they get a tax deduction for doing it. I don't care if they're wealthy employees, they're doing a good thing here. So anyway, that would be something where it has nothing to do with accommodation. It has to do with the fact that it's subsidized work. The person was never earning SGA to begin with. Okay, so I'm going to make sure I post this page with it. I'll attach the prior video if I can come across it. I know there's a lot, so sometimes I have to do a little search, but it might be reiterating what I say here. It might have some additional stuff. Anyway, that past accommodated work, if it's in your last 5-year window, which is the new look back window, thank goodness, it could be a stickler. So we just have to take note of it. And of course, if your evidence shows that you couldn't do that job anyway, for instance, maybe you had to quit that job because even with the accommodation, it was too hard, or you got fired for lacking performance. Those are real things you want to get documentation of, particularly if it's the employer saying, she's just not able to do it even with the accommodation. All right. Ciao for now, guys. Talk to you later.